This topic is homes and bankruptcy. Most people filing bankruptcy do not own a home, but a lot of people that don't own a home want to get rid of their debt so they can qualify. About 15% of Geraci Law bankruptcy cases, both Chapter 7 and 13, do involve people who are entitled to their principal residence. There's a difference between being on a title to your principal residence and being on the title of some other kind of real estate. So we have to ask you a bunch of questions to tell you if we can protect your home, that is your residence, in either Chapter 7 or 13. Remember, there's a difference between your residence and a property that is not your principal residence. First of all, let's talk about principal residences. Who's on the title? Who is on the title? Most people received a title interest in the home they live in when they purchased it because the seller issued a deed to you. So get out your closing papers, look at the deed or the title policy, and it's going to say who the grantor or the seller was and who the grantee, hopefully you, who received the title interest was. Is one of the people listed as a grantee you? Is anyone else listed as a grantee? If it wasn't a purchase but someone quit-claimed the interest to you, you should get a hold of that deed, take a look at it, and see exactly what interest they quit-claimed to you. The question of who is entitled to what is explained by the chain of title by these various deeds. So this is a complicated subject. Second, is the deed by which you took title recorded? I've seen cases in which mom issues a quitclaim deed to the house to son, and son takes it, puts it in his drawer, never records it, or mom never gives it to him. If it's not recorded and you file a bankruptcy, that deed has no effect whatsoever. In fact, if I give you a deed to my house and you put it in your pocket, it's good between you and me, but it's not good if you file a bankruptcy case because the bankruptcy trustee takes title as a bona fide purchaser without any notice. And in most states, there's a recorder of deeds, and if that deed isn't recorded, it's beyond the chain of title. Not good. Each county in most states has a recorder of deeds and a grantor-grantee index. Properties may also have a property index number or a PIN, P-I-N. So you can easily look up your property, see the chain of title, going back to the original subdivision if you like. You'll also have a title policy that tells you whose interest they're insuring. One person or company deeded it to another, and then to you. But if you don't see a deed to yourself, you may not be entitled. The seller, possibly, or you, may have never recorded that deed, and we never file a Chapter 7 bankruptcy without making sure that deed was recorded. And you can't just record it late, 2 minutes before you file the property. It should be recorded when you thought you purchased or took title to the property. So unrecorded deeds, not a good thing in a Chapter 7. The bankruptcy trustee will step into the shoes of a bona fide purchaser and take clear of any mortgage and free you clear of your interest if it's not recorded. So the third question we ask is, what's your real title interest in the property? How much do you own? Assuming you're on the title, in the deed by which you took title is recorded, are you a joint tenant? Are you a tenant in common? Are you the sole title holder? Do you hold it with a spouse's tenancy by entirety, as community property, or in a land trust? Closing papers should tell you all of that, assuming there have been no transfers or recorded since the title was last brought down. Another question, what's the value of your interest? So let's say you and your spouse own your residence as joint tenants, and the residence is worth $400,000, your mortgage is $300,000 with no second mortgage or HELOC. You'd have simply put $100,000 then in gross equity. $400 value, $300 mortgage, $100,000 gross equity without taking off any costs of sale. Since you have a undivided 1/2 interest, you have $50,000 or half the equity. How much of that can you protect? in bankruptcy, either in Chapter 7 or 13. In Chapter 7, it depends upon whether your state has state or federal exemptions. A lot of times, a state exemption will be like $15,000 or $30,000 or even $75,000. That's exempt from creditors. If your state has federal exemptions, that may be applied also. People who have regular incomes can pay out sufficient amount to unsecured creditors to protect a house if your exemptions don't cover it by filing Chapter 13. For example, if it's a close call, when we do the numbers, we might recommend a Chapter 13 that pays something to the unsecured creditors to protect the equity in the house. Sometimes one spouse is filing and another is not. That's another situation. Sometimes in a situation where you have property held as tenancy by the entireties, and a spouse has already filed a bankruptcy case, you don't want to be the second spouse to file a bankruptcy case because your entirety's property won't be protected. Now, definitely, if a foreclosure is threatened and you're behind in your mortgage, you're behind in your condominium payment or your homeowners association payments, Chapter 13 can allow you to force them to take your current payments going forward and give you 36 months or more to make up the back payments. In a foreclosure, Chapter 7 is of no help. If your house has already been foreclosed on, Chapter 7 can eliminate any deficiency payments. If you're current in your mortgage payments and your equity is protected by the exemptions, we may be able to file a Chapter 7, even though you've got a home and a mortgage, and reaffirm your mortgage debt. And in that case, your house is not affected by a Chapter 7 filing. Geraci Law is proud that we haven't lost a house in any bankruptcy in 40 years as long as you provide us with the proper information to start out with. Since we can run the numbers and advise you properly and show how to protect your house in either Chapter 7 or Chapter 13.